Good evening and welcome to the annual celebration of privacy and the presentation award ceremony, including the Brandeis Award for 2017. My name is Mark Rothstein, and I've been given the privilege of being the chair or the master of ceremonies or the whatever. As long as there's no joke telling required, I'm happy to comply with that. This evening we have some very special guests, and I want to introduce them to you now. And they are members of the Brandeis family, and 4 of them are with us. So 2 of Justice Brandeis' grandsons are here, Frank Gilbert and Walter Rauschenbusch. And 2 of Walter's children, so Justice Brandeis' great-grandchildren, Paul Rauschenbusch and his sister Lorraine Busey. And we'll be hearing from Paul later in the program. So I want to begin by saying a few words about Justice Brandeis that you may not have heard in the past, and his connection to privacy and why we're here this evening. When Deborah Peel asked me if I would do this, and it took me, 30 seconds to say yes. Anything that is attached to Brandeis is a presumptive yes. And for those of you who don't know, I live in Louisville, Kentucky, which is the birthplace of Justice Brandeis in 1856. I also teach at the Brandeis School of Law of the University of Louisville, where Justice Brandeis' remains and those of his wife Alice are buried in the portico of the law building, just where Justice Brandeis designed that his final resting place would be, and where he also donated not only his money, but all of his personal papers. And so it's a destination place for Brandeis scholars and has been for many years. In addition, my principal office at the medical school is 2 blocks from Justice Brandeis' childhood home, and I pass by it all the time. So I breathe the Brandeis air, notwithstanding the fact that I've concentrated much of my work on privacy. Brandeis was born before the Civil War. He joined the Supreme Court in 1916, and he rode a horse and buggy to the court until traffic in Washington made it unsafe to do so. He died in 1939 before the U.S. involvement in World War II. So the question is, how can someone whose roots are in the 19th century and early to mid 20th century still have any relevance to us in the 21st century? Brandeis' interest in privacy is actually related in many respects to advances in technology. One of the main reasons why he wrote his famous law review article in 1890 in the Harvard Law Review, The Right to Privacy, with his law partner, Samuel Warren, was because at that time, cameras were becoming increasingly portable, and so people could take them to events. And this led to photo-enhanced gossip columns in newspapers. Sam Warren's wife, Mabel, was the daughter of Senator Thomas Bayard of Delaware, who unsuccessfully sought the Democratic nomination for president 3 times. So the family was well known as a society family and was pictured and described in the Boston papers as well as other papers on the East Coast. So Warren thought this was a terrible thing, and he asked his partner Brandeis if he would work with him to try to figure out a way that the law could prohibit these kinds of what he viewed as unfair and detrimental invasions of privacy. Another famous writing of Justice Brandeis dealing with privacy also is related to technology, and I'm referring to his famous dissent in the Olmsted case in 1928. The issue in Olmsted was whether an 18th century document, our Constitution, and its Fourth Amendment prohibition on unreasonable searches and seizures, applied to the 19th century invention of the telephone in 1876, and the police wiretapping of a suspected bootlegger in the Prohibition era of 1920s. The court decided that because there was no physical invasion, there was no violation of the Fourth Amendment. And Brandeis' dissent, even if you're not a lawyer or interested in the law, if you're interested in privacy, it's the most magisterial description of privacy that I've ever read, and I've read it many times, I can tell you that. So the reason why Brandeis' view on privacy are still important today, that is because in resolving the privacy issues of his times, Brandeis not only applied the documents of his times, but he thought ahead to the future as well. As he wrote in Olmsted, "The progress of science in furnishing the government with means of espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home. Advances in the psychic and related sciences may bring means of exploring unexpressed beliefs, thoughts, and emotions. Can it be that the Constitution affords no protection against such invasions of individual security?" So Brandeis was applying the law as it existed, but thinking ahead to what might happen in the future. New technology always challenges us in terms of privacy rights and weighing the public interest and the private interest and so forth. These things happen on a recurring basis, and you all know that. I just want to share with you one recent development that was reported in the journal Science in the issue of May 12th of this year. Science reported that there is a new genome sequencing machine that has just been developed. Well, that shouldn't surprise people. They're doing that all the time. What's unique about it is that it can fit in your pocket. These are not only pocket-sized, but they cost around $1,000. This is not the $1,000 genome test that we've all heard about for many years. This is the $1,000 genome sequencer. The devices use nanopore technology, which I can pronounce but not describe. And according to the people I talked to, it's not quite ready for prime time, but they're making tremendous strides. Can you imagine the potential effect of on-the-spot genome sequencing in various areas, such as criminal forensics, on surreptitious testing of individuals in paternity and other domestic relations matters, in health research, including that performed by so-called citizen scientists, on public health, clinical genetics, and many, many other areas. I think it will be very challenging to balance the benefits of this new technology with the range of privacy threats that it poses. For example, should we regulate the use of this technology, prohibit it, regulate those who can use it, license them? Should we attempt to prevent the non-consensual testing of individuals or the publication of the results on the internet? In developing our legal and societal response to this emerging technology and many others, we would be wise to consult the writings of Justice Brandeis. I can tell you that I will.